Hi, welcome everybody. Welcome to Santa Cruz Works Clinic, Protecting a New Venture's Intangible Assets. I am your host, Doug Erickson, and I also like to introduce Matthew, and Susan is here as well. Can you guys say hello?
Hello.
Hello.
There you go. We have a wonderful team of people that are helping us day in, day out, and I won't go through all their names, but they are visible there and just fantastic folks. We couldn't do this without the help of our sponsors, and as you can see, there's quite a few there. I won't name them all. Would like to make a special mention to a new sponsor, Look Back, and you can read all about them in our newsletters. By the way, we need each other. If you are not a member, we would love to have you. It's a very low price for, I think it's 99 bucks a year, and you get to attend 5 events at no cost. So if you feel up to it, please join today. Go to www.santacruzworks.org. Thank you.
First of all, intangible assets and a new venture. I'm Pat Riley, the friendly neighborhood IP attorney. Thanks for joining us today. I work mostly out of Next Space downtown, but I have a home office in Aptos, which is where I spend most of my time now, of course. I need, of course, to start a discussion of legal topics by making the point that anything I say here is general information, shouldn't be acted upon without consulting an attorney, because for one thing, these laws change, especially IP law often changes based on the last federal court ruling. So be aware, these are all good ideas I'll be discussing, but pursue them further before you take any action based upon them. Don't rely upon them as legal advice. So why are there IP rights? Intellectual property rights, which are included in intangible rights, are the only civil right that's mentioned in the body of the Constitution itself. It points out that Congress has the right to protect the disclosures of authors and inventors for the purpose of promoting the progress of science and useful arts. So it's a very interesting civil right, and it's in the body of the Constitution, and it actually, the aim of it is specified. It's not to make inventors or authors or artists wealthy, it's to give them certain protections so that they will disclose their work and their findings to others to basically help us support the general public or aid the general public. So I go back to that right, that principle very often, saying, well, why is something happening with a patent right or a copyright? You know, what's the reason for that? And the rationale is this: the law is there to promote the progress of science and useful arts. Now, intellectual property is only one element of intangible assets, but it's the part of intangible assets that a venture or a person could make legal claim to. And those key categories of intellectual property are trademark, which includes trade dress, then trade secrets. By the way, typically 80% of a firm's value is in their trade secrets. So do not discount trade secrets, even though it's the toughest intellectual property to maintain, which I'll go into, of course. Patents, which are lengthy and expensive and difficult, but investors love them. And then copyright. And copyright is about the easiest right to legitimately claim. And it can also be very problematic, because you can't assert copyright unless you have copyright. And if you're sloppy in the way you're generating your code or developing copy for your website or developing any expression, including images, if you don't nail down the assignment of the copyright, you can end up half owning something where you only have an exclusive license, a non-exclusive license perhaps even, and the originator of the work actually retains the copyright. And also, if you don't have the copyright, even if the originator, the original author, is okay with all that, you can't actually assert it in court until you have that right. So I'll get to that in our talk. So trademarks first. Almost anything that can signify your good or service needs to be distinctive, and the legal justification for trademark is to protect the public. So keep in mind, on thinking through trademarks, it's not to so much create corporate equity or brand equity. Of course it does, But the reason the brand equity is invested in by our legal system is so that the public are protected, so that they know the source of the good or service that they're going for. I love to tell the story of Dolby Labs. When I first started out as a IP attorney, patent attorney, I had a good friend, Bob McGantz, who was one of the second wave of people at Dolby Labs. And as he got in, the first wave of patents were about to expire. And all the old hands at Dolby Labs thought the company was going to disappear, because when patents expire, you can no longer license the technology covered by the license at the same percentage, at the same royalty rate. You're not allowed to abuse a patent by fixing it to some other commitment, or by asserting a royalty rate after it's already expired. So they had like 135 licensees around the world who were using the Dolby Labs technology and had the Dolby Labs sticker. And they expected they were going to lose most of them. The company was going to have a terrible time. In fact, they didn't lose a single licensee, because by that point, the day-to-day value of the Dolby Labs engagement to their licensees was to be able to put the Dolby Labs mark on their products. Now, of course, Dolby had to keep up innovating, had to keep being on the forefront of innovation in audio engineering, audio equipment. But keep in mind that it isn't always that the tech by itself, the patents by themselves, stand alone. In this case, it was the trademark that was the really commercially valuable item of intellectual property that Dolby possessed. So again, I've been over this. This is about protecting the customer, the consumer, not so much protecting the owner of the trademark, although of course it does inevitably. I'm going to go moving quickly over this, but in the slides, which I'm happy to send you, there's some deeper discussion of the points I'm making in the presentation, but I know our time is limited right now, so I will flip through some of this. Trademark can be any number of things that you're using. Now, the best news about trademarks is that they can go on forever. The longest standing trademark in use in the English-speaking world is the orange diamond on the Bass beer bottle. That's been a trademark that's been honored since about like 1715, something like that. And as long as they, of course, it's under it's under U.S. law too. And here in the U.S., that's still a registered trademark as long as they continue to renew it. You renew it at the 5th year of registration, between the 5th and 6th, and then every 10 years from the original issue date, registration date. So year 5 to 6, year 9 to 10, year 19 to 20, year 29 to 30, and you can keep it going forever. That's the best news about trademarks. It's a perpetual asset. You want to register it for a number of reasons, mainly because if you send a cease and desist letter, it's a much weaker letter if it doesn't have a federal registration number attached to it. It's a much more burdensome process to sue someone for trademark infringement under common law. Although I have asserted common law rights, you're not necessarily abandoning your common law rights, but it's a very good idea to register it if you think there's any value at all in your trademark. There's some more advantages, which you can look through at your leisure if you ask for my slide deck from Matthew or Doug. Now, trade dress is similar to trademark, but it's more about something that isn't exactly the mark on the image, but it's just the overall appearance, the overall aspect of it. I mean, you could imagine going up to a can of cola that's colored and lettered as though it was a Coca-Cola or a Pepsi-Cola or an RC Cola, some other brand, so that if you just glanced at it, you get the sense that, oh, this is from that well-known manufacturer of cola that I like. Well, that's also something that's assertable in court, that a competitor is using very similar markings and appearance, and even sales techniques to appear to be your venture. So that's what trade dress is about. Here's some of the court cases that define what trade dress is. You can read this at your leisure, pointing out that there's all kinds of things that can be trade dress. So just because you don't have something that you could call a trademark, but people are in fact being confused, the public is in fact being confused by the source of goods, by the presentation of a competitive device, you might have a case. All sorts of things have been found to be trade dress. The most famous one was restaurant decor, a fast food restaurant. Actually, I don't know if it's fast food, but a restaurant copied another restaurant down to the colors, the organization of the tables and chairs, the layout of the menu. Wasn't quite copyright infringement, but it was trade dress infringement. These are a list of many of the things over time that have further, but that was the foundational case of trade dress law. So after the restaurant decor case, other findings were made in trade dress assertion. On to trade secrets. Now, what's the secret of trade secrets? Much like humor, the secret is timing and diligence. You have to act in a way where the party is committed to keeping the trade secret. And so I always cringe, I'll point this out, I always cringe when I get an email from someone that says confidential on it without any promise from me to give confidential treatment to their information. Now, naturally, as an attorney, generally speaking, it is confidential because even if you're not my client, if you're sending me information with the interest of retaining me or discussing retaining me, that's considered pursuing legal advice. So that's covered. But for person on the street, excuse me, to get an email that says, this is confidential, that's no way binding unless the other part, the recipient says, okay, I promise to keep it confidential. You really want confidentiality agreements. You want it to be a contractual commitment. And probably the single biggest mistake in confidentiality/NDA agreements is that the discloser didn't follow up and make sure that they pointed out what was confidential. So execute the policy. Mark things confidential that should be. Don't overmark either. I've seen where someone would post something in the lunchroom that was marked confidential. That's kind of behavior can actually invalidate all your confidential documents, because how does anyone know what's confidential if you're posting stuff in the lunchroom that says confidential on it? So be careful in how you do the notices and the markings. Do them properly, but don't overdo them. Now, trade secret materials can be quite broad. It kind of boils down to whatever the person promises to keep secret that you're disclosing to them. As long as that information isn't publicly available or somehow properly disclosed. And I got to warn you, this is really bad. If it gets disclosed, even improperly, you've lost your trade secret status. So yeah, you can sue the party who disclosed it, perhaps, but you can't retain the rule of confidentiality to it. So it's all about diligence. Timing, meaning getting things signed prior to disclosure, getting agreements made and commitments made prior to disclosure, and then following up on those disclosures with diligence. On to patents, my primary bailiwick. I'll talk mostly about patent rights, but then touch on some international patent dynamics, patent cooperation treaty. And there's an EU industrial design right, which is much like a US design patent. Not exactly, but much like it. And I'd like to let people be aware of it, that if they're developing products that are likely to see the European market as a major market, that you can have design rights, which are, by the way, design patents and EU industrial design rights are much less expensive and less onerous in the process of obtaining. So I'll get back to that at the end of this. So patents have quite a history. The very first patent known was in ancient Greece, where every year, whoever came up with the best, most popular recipe at the festival of Sybaris would get a year's right to be the only one to use that menu, cook on that menu. So it was the very first thing that we might think of as a patent right was related to food. Then Florence and Venice both came up with, we would pretty much consider modern patent rules, where requirements, you have to just fully disclose the invention, so one of ordinary skill in the art can make and use the invention. And then the government in return will give you a limited exclusivity to that invention. Now, the statute of monopolies in England is the foundation of English traditions of patent rights. And ironically, at that time, the Crown would give a monopoly to someone who brought a new invention into the realm. You didn't actually have to be the inventor. If you went off to China or India and came back with a new way of working metal or a new way of building a ship and presented it to the Crown in what of course is an open letter, a patent letter, presented that to the Crown, and the Crown decided it was valuable, they might give you patent right on it for a limited period of time, even if you aren't the inventor. Now, of course, in the US and every country I know of, you have to be the inventor to sign the patent application or to be involved in the submission of the patent application. There's two types of US patents. There's also plant patents, but if you're in the cannabis business, give me a call about that. But it's a pretty niche thing that I don't do a lot of. There's utility patents, and then there's design patents. Now, sometimes you hear people talk about business method patents, or they'll talk about other flavors of patents. But really, by law, there's plant patents, which we're not going to discuss. There's utility patents, and there's design patents. Design patents are about the ornamental design of an object. For example, I often use the original Jaguar on the hood of the Jaguar car. I love Jaguars, so that's the example I use. Originally, that three-dimensional sculpture could have been a subject of a design patent. Of course, they only have a 14-year term, so the term would have run out by now. But that's the kind of thing you could get a design patent for. And it's very important that it not be functional. The moment it's functional, then you have a problem, because then it's, no, that's a utility patent subject matter, not a design patent subject matter. Now, what are patent rights? Patent rights are the right to make something or to use it, practice it, in other words, or sell it, or even offer it for sale. Because the point being, during the patent term, no one is allowed to compete with you. They can't even offer to sell something that would infringe your invention. That in itself is an infringement. There are many patentability requirements, but they can loosely grouped as first as a patentable subject matter. That's not usually a big thing unless you're in software or in information technology. I'll be discussing that in a moment. The key thing about patentable subject matter is it merely an abstract idea? Is it just a dynamic of nature? Is it something so broad and unlimited that you can't really fit it into something that's worthy of patent protection? So that generally is to say only enters into questions of patent applications that are software enabled, which of course are most of the work I do. So it's an area I'm very familiar with. Then inventorship, as I mentioned before, you can't merely discover or disclose something. You actually have to be the inventor. It needs to be new. Now, new is the weakest barrier, easiest to overcome unless you're not new, right? But generally, when I deal with experts in an area who are going to the trouble to get a patent application drafted and filed, they usually know their area well enough that we can determine novelty pretty quickly. Now, you can always be surprised because novelty relates to what's in what we call the prior art. And the prior art is what's already out there in the public, and it could be published, could have been published on anywhere in the world, or have been published on or practiced in the US, then you break novelty. There are some, of course, defenses, time limit defenses to that, but that's the problem with novelties. You never know what's out there, especially in software. By the way, there was a major US company that is reputed to have maintained a magazine in Bulgaria in which they published invention descriptions in that magazine solely for the purpose of being able to say that no one else could get this patented because it was published on somewhere else in the world in a scholarly magazine. It didn't have to be scholarly, it could have been a daily magazine. But there are things that have gone on about how do you decide to disclose your invention, even if you decided not to pursue patent protection, but don't want to draw a spotlight to it. So there are ways of doing that. Finally, non-obviousness, and that's usually the real argument, because non-obviousness is the condition where if someone knows everything in the art they're practicing in, and the art is kind of defined by the examiner's thinking, whether it's IT or whether it's truck engines or whether it's methods of rendering matter on information on a screen. The examiner decides what that scope is, and then he looks at everything he can find there. And of course, he's surrounded by people with decades and decades of experience in the area of art that he's working in. We use the word art to mean technology. It's the area of technology / art that he's working in. So often the examiner will come up with 2 or 3 or 4, I've even seen 5 references put together that said, well, one of ordinary skill in the art could know about all this prior art because it was out there. And if he knew it all, he or she knew it all, they could combine it to equal your invention. Usually it's two pieces of prior art, but I've seen them go way beyond that. So non-obviousness is usually the real killer, especially in software work. Now, what is patentable subject matter? As I mentioned, abstract ideas aren't, but articles of manufacture are machines, compositions of matter, and methods of doing things. Let's see. If you grab, I'm making sure time here. Okay. When you're looking at a patent, you want to look at first the abstract, which is what it sounds like. Used to be much more important before IT, and we could do keyword searching, but still, it's there. It's good to glance at to see if you're concerned about the contents of a patent. Then the specification describes how to make and do, how to practice the invention, so that one of ordinary skill in the art, without undue experimentation, can practice the invention. And finally, the claims are what's legally possessed by the patent owner. And analyzing the claim, writing the claims and analyzing the claims is the key area where experience is helpful, where somebody who's done that before, having them involved is very helpful, whether it's a patent agent, a patent attorney, or someone just very familiar with patents. Claim analysis is probably most of the value of having an experienced person involved. Here's an example of a simple composition of matter patent claim. I'll just leave that on for a moment, give you an idea. All kinds of things that can, if you can describe it as compositions of different elements, then boom. Of course, then it has to be invented, it has to be new, it has to be non-obvious, but there's an example of one. Here's a more typical patent. There's a method, a 3D printing material system and method. Now, when it comes to what the claim means, that can often be very well argued. For example, particulate matter, a particulate material, what does that mean? What is a plaster? What makes a fluid aqueous? At what point is it aqueous? What percentage of water does it need to be an aqueous fluid? What is water soluble? How, and it says partially, so what's partially water soluble? Where do you draw the line on that? What's actually an adhesive? To what extent of adhesion does a material need to be truly an adhesive? And the accelerator, where what form essentially, what is essentially solid? Is that 20% liquid, 15% gas? That's what happens when you go to court. In fact, it's also what happens when you're going through the prosecution. The examiner will interrogate your claims, and in litigation, the infringer's attorneys will interrogate your claims as well to say that, well, you have a valid claim there, maybe, or even if we agree you have a valid claim, we're not infringing because we're not using an aqueous fluid because we only have 30% water, or we're not really an adhesive, and we don't really have evenly distributed layers. So that's where claim analysis and claim drafting is very critical. Now, as I touched on before, if you're working in information technology, the ways to get around the criteria that are of note regarding patentable subject matter are, first of all, is the system that's running your software-enabled invention, is it unique as opposed to a general purpose machine? For example, there would have been a time when a GPS on a phone would have made something unique. It wouldn't have been a common element of a phone, but it is now. So now you couldn't get away by saying, oh, I put a GPS circuit on the phone, so therefore that's not going to do it. Next is, let me get back to that. But on the other hand, if you had some interesting sensors, like let's say you had something that sensed the rate of radiation decay, that's arguable because not many computers have that as an element of their architecture. So next, transformation of matter. And this is the best case. That's where you're actually doing something that changes something physically. My best example is if you had a new way of mixing paint. The paint, as it was mixed, would change in some way. The color would change, presumably, or some other physical aspect of it would change. And that would satisfy the transformation of matter. So you could use a computer hooked up to a robotic stirrer and the method of putting in these particular paint materials or precursors and mixing them together. That could be patentable subject matter. Lately, though, and that's in the last couple of years, the courts have been much more open to the concept that you're advancing the art. I, for example, have gotten a lot of patents issued for communications modalities, especially relating to Salesforce. Salesforce's limitations in their bandwidth and their service. So ways of getting around limited bandwidth communications scenarios. There's computers talking to computers. They're not particular machines, they're not transforming matter, but they are advancing the art of information technology. You just have to be prepared to make that argument that with this invention in hand, you're able to do many new things much more powerfully than you were able to do before with the given existing information technology. Also, lastly, the courts are more willing to, the patent office and the courts are more willing to accept claims that have a limited scope. If you just say, oh, this is good for anything that emits communication signals, but if you say, oh, but if we do it this way, it enables the car to run faster, or it decreases the increases the efficiency of a motor. They're much more willing to say, okay, you're really drilling down a particular piece of art there. Nobody's been applying that, and it's not obvious to apply this to that, and you have a narrow area of benefit. So I would often now I think of adding claims like that when I think our invention may be very powerful, but maybe it's overly broad and would a broad claim might be dangerous. And so you want to add some dependent claims that narrow the scope of the invention that is patented. Now, the responsibilities of everyone involved in the patent process of a particular patent application include duty of candor. We have to disclose material prior art that we're aware of to the examiner. Now, we don't have to be duplicative. We don't have to keep sending them 6 things that are pretty much that are in fact the same thing abstractly, or inform the examiner of things that he or she has already informed us of, that they already know about. But we can't keep anything up our sleeve. If we're worried about some particular piece of prior art, if we're worried about it, that's a sign that we need to let the examiner know about it. And if the examiner doesn't seem particularly knowledgeable, then we go a little further and we make sure that he knows of everything. Well, yeah, we should make sure he knows of everything material, but we don't need to keep informing him of things we've already informed him or that he's already aware, he or she is already aware of. But there's no duty of discovery. This is particularly important in small teams, that you don't want your team members going out and just doing patent searching, prior art searching, and not telling you about it. It's really good to have one person as the focal point for the prior art information, and best is only one person does that type of searching. So everyone involved management team, tech team, inventors, should all be quizzed about this, and whatever they know of should be told to that person and let that person collate it. A horror story to mention is, imagine you have a patent that's allowed to be issued, and this has happened, I've seen this happen. And during that period of time, one of the inventors comes back and says, oh yeah, this is really great because so-and-so must be infringing our invention, because look at this patent document I came up with. So look at this magazine article that's 5 years old. Well, now you got to stop everything. You got to put a hold on the process. You got to send the prior art to the examiner for consideration. And I've had to do this, and I've yet had it to cause a failure of issuance. But if we hadn't done that, then we would be in jeopardy, and the patent could be invalidated later by a lack of duty of candor. So no duty of discovery, but please make sure you keep track of what is being discovered internally, especially because people leave, right? Somebody leaves, and 10 years later, you found out they knew something they didn't mention to you, and now it's a big problem. Naming actual inventors, yes. Problem here is you can't just add the engineering manager or the co-founder or whatever just because to be nice. The inventors need to be named who actually contributed to the invented matter that's in the claims. And you can't exclude someone either. If they've left the company, but they were a co-inventor or the inventor, you just need to deal with that. Track them down, get them to assign the application, get them the right to make the oath that they're the inventor, and go through the formalities. But you can't just be nice in naming, or be can't be mean either and refuse. It has to be literally true. Who are the inventors? Who are the co-inventors of this patent application? I'm including this for your later consideration, just a timeline and what to do if you want to file internationally. Basically, from the earliest filing of a patent application, be it provisional or non-provisional, I'll say again, it could be the provisional filing. You have 18 months to file. Oh, no, sorry, about 12 months to file a patent cooperation treaty. And that gives you an additional 18 months, so a total of 30 months from the initial filing date, or priority date, we could call it. 30-month window from the initial filing date to decide if you're going to pursue patent protection outside the US. Those are your kind of key dates. T0, T12, so like around T10, T9, at 9 months, you really better be making up your mind, because you got to file by the 12th, by the anniversary date of the original filing. And then you've got 18 months to figure out if you really want to pursue the patent application in other countries for issuance as a patent, which of course can be very expensive. The US is the best bargain, by the way, when it comes to patents, especially in IT inventions. You get a third of the world's market, maybe a half on almost anything, at a much lower price than you would get pursuing much smaller markets per capita cost, pursuing other markets in the world. So as I mentioned, the industrial design right in Europe is of interest, especially if you are developing some kind of device that would be shipped. And the appearance of it is important. I'm sure you're mostly aware in general of the Apple, Samsung design patent infringements, where Samsung copied the shape of the iPhone based upon disclosures to them, which weren't quite trade secret, but were definitely infringements of the patent designs. So keep in mind that one potential intellectual property protection you can get in Europe is an industrial design right. Just put it in the back of your head, and it's generally much less expensive and much easier to get than a utility patent equivalent in the European Union. It does have a 25-year term, and they have a different test for whether or not it's new. By the way, I should go back, and I didn't mention the term of a US patent is 20 years from its original filing date, from its original priority date. Just keep that in mind. So, in fact, just this morning, I was talking to a client about a patent by another party we were concerned with. And first thing I looked at was I saw it had been issued in 2000. So it told me we had nothing to worry about. So 20-year extension from the filing date, not the issue date. So the fact it was issued in 2000 was double security. A little bit more industrial design rights, and that modular systems are an eligibility. So if you're Eurocentric in some level in your marketing plan, be sure and inquire about EU industrial design rights. Now, copyright. Let's see, how much time do we have? Oh, we're at 40 minutes. Let me spend 3 minutes on copyright, because copyright is incredibly complex, and I just want to give you the very basics, and then we'll go to Q&A. As Mark Twain noted not that long ago in the big picture, copyright law is a bear. The copyright protects the expression, not the actual underlying idea. The basis of infringement is you've got to show you have the valid copyright. You need to have some proof that the defendant copied it, and you have to prove that what they did was an improper use, an unauthorized copying. There are public concern. I'm going to skip through this. Advantages of registration, that's very important. Oh, going too far. Advantages of registration. So you want to file so that you can actually send a cease and desist letter, because you don't really have many rights without the copyright. Now, what I was alluding to at the beginning of the talk is that just because somebody does something for you and you're paying them for it doesn't mean you have copyright. If they're an employee and their job is just to produce that work, yes, then your firm, or you, perhaps even you personally, if you're their sole proprietor or employer, then you would own copyright. But the common case is you use a contractor, and the contractor may or may not have promised to give you copyright. but it's weak until that author of the work, we call it, even if it's a dance routine, the creator of it is the creator of the work is called an author. The author still needs to sign on the dotted line that you have copyright. So don't miss out on the formality of getting an assignment made and then of making the registration. Also, if you have the US registration and you sue, if you haven't waited too long and you registered early, then you can get attorney's fees, and then you can get up to $150,000 damages per infringement, which means that a cease and desist letter carries a lot more oomph if there's a copyright registration number attached to the cease and desist letter. Okay, on fair use, don't rely on fair use. That's fair use is very complicated legal analysis, and don't blithely rely on, oh, I'm a good person, I'm doing a nice thing, so I'm protected by fair use. Don't think about that at all. I think we should go to Q&A now. Thank you very much for your patience. I will assert that I don't usually talk that much. I try to spend more time listening, and I will ask Matthew or Doug to step in. Or
Great, thank you.
Susan, for that matter.
All of us. No, it will be me, Patrick. Hey,
Okay.
Thank you so much for your presentation. Very, very informative. So we do have a few questions, but if anybody on one of the attendees has a question, please put it in the Q&A. We do have a couple minutes to answer those questions. So here is your first question, Pat.
Okay.
If I launch a crowdfunding campaign, would I need to file a patent application beforehand?
Okay, I'll break that down. First of all, it's when you say need to, you don't want to remove the possibility of getting patent rights. So the bottom line is, if you publicly disclose something, you only have 1 year to file the patent application. However, just because you talk about the result of your product doesn't mean you've disclosed the invention. If I tell you I'm selling tickets to Mars and selling them, I'm taking money and I'm giving you a ticket, that doesn't mean I've told you how I designed the engine or what fuel mixture I used. If I keep the invention itself secret, then there's a pretty good case you can maintain your patent rights. But I suppose I would say any public disclosure question is like asking a doctor, how many cigarettes should I smoke? I mean, I would say you should always apply before you disclose publicly. And there's a more likely concern, which is that if you start disclosing your idea loudly to the public, there's a really good chance that somebody's out there who's working in a similar area and on a similar vein. And they're not going to steal your idea so much. Well, of course they could, but I'm not going to, well, they can't get away with it. That's very hard to do. But I'm concerned you motivate somebody else to hurry up and file their patents. And now you got a problem because somebody who independently invented filed first. And that's perfectly legitimate. They're allowed to do that. So file early and often, but no, you don't need to file first if you're going to take the risk, but it is a risk.
Okay, great. Thank you. Okay, next question. This might be a two-parter here. How can a company with little resources legally fight to keep a trademark or patent if a large company with unlimited resources fights to claim it?
Yes, that's the great weakness in our legal system, is that if you have deep pockets, you can drain the small fry opponent. I don't have an answer for that, except that register the trademark, protect your, and make sure that you have a clear, legit legal case that's your trademark. And from there, I would say it's a case-by-case analysis. It's a dilemma we have in our legal system, where in fact, the IP law in general, it's a problem that you can sue people and bleed them to death because the court costs are so high. I don't have a magical solution for that.
When you're actually applying for a patent or going through that filing, going through the process, with the person that you're doing that with, would they usually give you a little heads up on, you know what, over time, you're probably going to be, paying this amount of money or so just to fight this claim? Is that something that you get counseled on?
You mean if I have a client who's applying for a trademark and I'm
Yeah.
going to tell them you're going to get sued?
Yeah.
To the extent that I've had that kind of situation in my real life, yeah, I've gone through like 12 possible trademarks with the client until we found something that we thought was free and clear. That's really the trick, is especially in the early stages of a company, you don't want to pick a fight that's going to just drain you. So the best thing is to do a really good search. And there's services out there that for, I don't know, on the order of $1,000 will do a really thorough search of publications and state trademark offices, and of course the USPTO. So I would say keep looking until you find something that all of your searching indicates you're free and clear. That's the best you can do.
Okay, great.
And that's
Thank
the
you.
most I've counseled people is all right, let's take this new idea and let's go do some searching on it and see what we find.
Great. Okay, last question, unless there another one pops up in the Q&A. It's two-parter again. Can you explain the differences between a mutual NDA versus a one-way, and
Sure.
how to determine the duration of confidential information before the other party can use or make public?
Okay. The first question is pretty straightforward. If it's a one-way NDA, then it's just recipient and disclosure. And the whole NDA is written, the disclosure is such and such, and the recipient has these duties. And about the only duty the disclosure would have is to verify what the trade secret is or what the confidential information is. So if you see terms like recipient and disclosure, that's a pretty good tip-off that it's a one-way NDA. If it's a mutual NDA, then the terms will all be the parties, that the parties agreed to, the parties are obligated to, and all those commitments are mutual. Even if that word is not used, the phrasing is that the parties have these responsibilities each.
Okay, great. Okay, well, thank you very much. I think that's all the questions we have. Actually, one more question. If somebody wants to contact you, what would be the best way to do so?
My website's ipsociety.net, ipsociety.net. You can send me an email at patrick@ipsociety.net. Or they can reach me through Santa Cruz Works, of course.
I like that answer. Okay, well, thank you very much for the Q&A and presentation. Now we will give it back over to Doug.